Hey, this is Elizabeth Potts-Weinstein, and what I'm going to do today is to go over and kind of show you some contracts that you might be using. So one of the things that people ask me a lot is it okay for me to use templates and form contracts that I get online? And a lot of clients come to me, they've been using templates or form contracts. They either got from a colleague. It's very common to get it from one of your colleagues. They got it from the International Association of Certification of whatever is the thing in their industry, and they got those templates from them. Or they got it from some website. They may have just Googled. They may have downloaded it from one of these official lawyer-ish, theoretically written by a lawyer sites. Sometimes they actually did get it from an attorney. I'm not saying that the attorney ones are always better. But what I wanted to do is kind of go through a couple different things I found online just by Googling free template such and such contract to give you an idea of the problems that inherently happen when you use templates and forms and what you can do to find good ones. So let's go ahead and look at, this is one I Googled, was a virtual assistant contract. And this is just the first thing that came up on Google. It's inside of a blog post. So we can go ahead, oh, that's a little bit too close. We can go ahead and look at this contract. Let me scroll down a little bit. And let me zoom in a tiny bit. There we go. Okay. This is a work for hire agreement. Now, it's interesting that this person called it a work for hire agreement because work for hire means something very specific in copyright law, and I don't think that's what this person means. I would call it a virtual assistant contract or virtual assistant agreement or a contractor agreement or something like that, because work for hire is about copyright law. This is the kind of thing that a lot of times non-lawyers do, is they start using legal words because it sounds more legal when really it's better to use the regular word. Lawyers do this too sometimes. So this work for hire agreement is made this Thursday, November 17th. Obviously, you don't need to put the fact that it's Thursday, but that's not wrong, between Virtual Assistant Services and the company having its principal place of business. This is a great example of the fact that you actually want to just start with, what's the date? The date could be here or it could be at the bottom where the signatures are. Between the two companies. You want to make sure that you have the real names of them and make sure you have identifying information. One thing that I do is I want to know the real legal name of the company and then where it's incorporated or formed, or its principal place of business if it's not incorporated, because you really want to be able to identify that it's a real company. I also, if I'm around, I'm going to look up that company, make sure it actually is an LLC in Nevada or whatever, because it may not be. And it may not be because the other side is bad. It just, they actually are no longer incorporated because they forgot to pay their annual fees or something, So you want to look that up, put that in there. It identifies the company and we know which one we're talking about. It says, this agreement, they're defining it as the word client and blah, blah, blah. I don't put a whole bunch of sentences about that. I just put the word client with the quote marks, just it right after the name of the company, but fine, it doesn't really matter. Description of the services, beginning on certain date, Virtual Assistant Services will provide the following services. That obviously, it's almost always where you start. I actually like to put something in between these two clauses saying, Virtual Assistant Services is a company that does XYZ. Company is a company that does XYZ, company wishes for Virtual Assistant Services to provide virtual assistant services, right? I like to have a little introductory paragraph. In fancy lawyer contracts, they're called recitals. They are the whereas clauses. I think the word whereas is like a bizarre legal word, so I don't ever say it. I just like have a paragraph that just says who the people are. It's helpful to have this. It's not a binding thing to have any of that stuff, that whereas, but what it does is it helps frame the agreement of who everybody is and show that you intend that both parties are really real businesses and that the virtual assistant company isn't an employee of the main company hiring them. So that's helpful. Service location. The service will be provided at the virtual assistant services place of business. That's actually good to help show that they're an independent contractor. Their schedule. I would be a big red flag here that they might be an employee because you're giving them a schedule. I understand that virtual assistants, need to be able to answer the phone if that's part of their services. But then I would put that in here. I would say, they need to be available to provide these services during this time so they can answer the phone. Like, I would put why you require those hours, because you actually don't care when they are transcribing the audio they're supposed to transcribe for you as their virtual assistant. You want to create as much evidence in this contract that the virtual assistant is an independent contractor and not an employee. So the more language you can put in there that you don't require them to work certain hours except when specifically needed, like to answer the phone or something like that, the better. Payment for the services based on an invoice. In a perfect world, virtual assistants would get paid a flat fee, but that doesn't actually work. The reason is that the more you pay someone by the hour, the more it looks like an employee. Termination. Either party upon 5 days written notice may terminate this agreement, provided, however, that each party may terminate the agreement immediately without prior, notice, because they forgot a word, in the event of breach of this agreement by the other party. Okay. Upon termination, shall invoice be paid in full. The termination, well, first I would want to put term is, periodic. I don't know if I like to have it be indefinite here. Like the term is forever until it's terminated, because it's more like an employee. But I get the idea if you have a virtual assistant for a long time. I would probably put in there something more about the 5 days written notice stuff, is like how that works, and the terminating the agreement in case of breach. I'd probably put for good cause instead of breach, or for substantial breach or something, like, because I don't know, these are inherently vague things. And actually, you may actually want to require everyone has to give 5 days notice. My contracts that I write, typically, even if someone breaches, you still have to give 5 days notice, and you give them opportunity to fix it. And I think that's very helpful, because technically, like, if you pay the invoice late, that's a breach. And we do that sometimes by accident, and it's helpful to have something in there to be able to cure accidents. Non-disclosure and non-solicitation. There's actually a couple of clauses in here about this. One of the things here you got to be really careful about when you're talking about non-disclosures, non-solicitations, covenants not to compete, is this is hugely based on state law. In a state like I live in, which is California, you can't have a covenant not to compete except for you can have stuff about trade secrets. And I mean, there's certain things you can't have, but it's going to be really, covenants not to compete are not going to work here. However, in some states they do. You also want to be very careful when you hire a virtual assistant, and the virtual assistant needs to be careful. It's actually realistic for you to do that. You, as a VA, have multiple clients who may compete with each other. They're all life coaches, and technically they compete. You don't compete with them, but you want to make sure that you're not going to be accidentally competing, if that makes sense. So be really careful about this stuff and exactly what it says, and also the state law. And you want to look at the state law of where the VA is located and the state law where the company is, and where the company is incorporated, as well as where their principal place of business is. Of course, you want to keep everything confidential. The VA agrees for the term plus 6 months. It won't solicit any customers or suppliers. That's what I mean. You want to make sure that that's actually possible. So you may have a supplier, you have AWeber is a supplier of the life coach's email list. You're saying you're not going to use AWeber? Obviously, that may not be able to make that promise. So you need to really understand what you're agreeing to, because in this clause you are. Relationship of the parties, independent contractor stuff. It talks about the whole fringe benefits. Yeah, I don't even care about that. I want to know is who's paying the taxes. That's what's going to get you. And there needs to be express language about this. In some states, Arizona, for example, Colorado, there are magic words that need to be in the contract. There may be other states too. I haven't researched every single state yet. Work product ownership. This is going to intellectual property. And I get what they're going at here, but you're probably going to want some more specific language. And it actually kind of goes with the non-disclosure clause, and there's also a confidentiality clause. All these clauses really should be thought of as together. I think what happened in the person drafting it is pulled these paragraphs out of different contracts because they're in some ways saying the same thing. This is something that happens a lot when non-lawyers, and actually sometimes when lawyers, piece together a contract from different places, is then you'll end up having clauses or different paragraphs that all say the same thing and say it in different ways. So it's inherently vague. And when you have a contract that is ambiguous, that's when you have problems. Because the point of having a contract isn't so you win in litigation. Hopefully it'll never be litigated, knock on wood. And my goal is for my contracts to never need to be in court. And the reason is because they are clear. If your contract is clear, you never need to go to court. Except for the very rare occasion of one of the people who signed it is a crazy person. And I don't mean that, I mean that in the sense of they're not logical, they're not reasonable, and they're out to get you in some way, shape, or form. And you can only do so much about that, and hopefully your contract will win in court. In the meanwhile, you want to have a contract that is clear so it's possible for a reasonable person of average intelligence to be able to read it and know what to do. So that's the goal. And if you have paragraphs that conflict with each other, it actually makes it so no reasonable person, even a lawyer, can possibly know what they're supposed to do because it doesn't make any sense, right? There's a liability clause here, which I found cute because it's all about, acts of God and all this stuff. Power outages and inability to contact client. I mean, these are actually legitimate things to talk about. I say it's cute just because it's the kind of thing that sounds very lawyery. But it is true that your business as a virtual assistant or whatever kind of contractor you are, you're subject to hurricanes and earthquakes and terrorist attacks and all kinds of craziness, right? And may not be able to do your job because of that. And it's completely without your control. Now, the virtual assistant will not be liable for loss, damage, or delay of client's project due to circumstances beyond the contractor's control. That's going to be, this is a very broad clause, actually. What does it mean to be beyond the virtual assistant's control? I don't know what that means. And that's like, I know the conventional meaning of that, but from a legal sense, that's very broad. And I would want more clarity about that and think of a better way to phrase it. Severability is one of those clauses that people put in contracts because it sounds very lawyery, I think. It's actually very important if you're going to put a non-compete in there because that way if the court finds that the non-compete clause, the non-compete paragraph is not valid, then the court may still let you have the rest of the contract. Signatures. One of the things you're going to want in here is that it's the party signs it for their company. So it doesn't sign Elizabeth Potts Weinstein. It's signed Elizabeth Potts Weinstein, President for EPW Small Business Law PC. Because then you're binding the company, not me as a individual. Very, very important. So that's a virtual assistant contract. And what I'm actually going to do is I'm going to separate these into separate videos and look at some different contracts, because this is becoming a very, actually, I think I'm going to go ahead and just do the other ones, because I think I've talked about a lot of the same things. Okay. Let me rearrange this a little bit. This is a coaching contract that I found just by Googling coaching contracts. It comes from the Certified Coach Federation. Let me get this down a little bit so you can see it. So very typical of the kind of contracts I see from my clients who are coaches. You know, this agreement is made between so-and-so and so-and-so. They agree to the following. Coaches are, well, from all the coaches that I see, there is some consistency among coaches and also therapists and many other people in helping kind of professions, health-related professions, signing it on in their own name, even when they are incorporated. You can hear my voice getting all like raised because I'm all indignant about it. I understand that as a professional giving him professional advice, you are personally liable for your malpractice. Hopefully you won't be committing any, but you are. And I think that because of that, because the personal nature of the service, we want to put our names on things. And of course your name will be on it, right? Because you're a human signing it. It's still between your company and the client. So it needs to be between your company and the client. Both parties agree to the following. And then he has a whole bunch of stuff about coaching. I think that's great to have that stuff in there. It's a great opportunity to educate your client. Has a bunch of stuff about the sessions and the procedure. This is actually really helpful to say what happens if the client is late. What happens if they want to reschedule? Really important things to put in your contract, okay? And really this is part of the services part. Now, one thing that's in here in the beginning is, you know, the coach and the client commit to working with each other for an initial 3-month period. Okay, that's fine. This needs to be more express in this contract, that the client is signing up for 3 months. Not this whole like commit to working with each other for initial 3 months. No, the client is signing up for 3 months. Like, it needs to be much more explicit that they are buying a 3-month package. That's what I want it to be. That's going to be very helpful if they flake out after a month. Okay, you may not want to enforce against them, or you may want to enforce against them. It depends how much money they paid, right? Because maybe they paid for that month and you're okay with writing it off. But you want this to be an explicit thing, because otherwise they won't comply with it, because they won't know that they agreed to it. All right. And you may say, oh, well, I talked to them about it. Well, what you said to them is not part of the contract, because we're going to have a clause in there saying it's not. But you know, I know this one doesn't have that in there. Confidentiality, you know, they agree to keep it all confidential. Obviously very important. Coaching fees. And this is where I say, you know, the whole 3-month thing. There's a free session, and then they discuss entering into it. There's a 3-month commitment, and then there's a monthly agreement. So what is this person agreeing to when they sign this? Have they had their opening session already? Because if they've had their opening session, why is this even on this sheet? It shouldn't be on there anymore, because that just makes it confusing. It needs to be that they're signing up for 3 months and that they're paying X dollars. And the fees need to be on here, because there's actually nothing on here about how much the fees are. There's no blank for that. And I get that this is a sample, but it should be a blank. It says it's X dollars. One of the things you may want to think about is, as a coach, you know, if you have people pay per session, and I'm saying this as a coach because for therapy there are different rules. Similar to how there's special rules for lawyers and stuff like that. In some of those professions, you can't force people to sign up for a certain amount of time, and there's no way for them to get out of it. But for coaching, you can have people sign up for packages. And you have them, like in this, the client receives 2 30 to 60-minute telephone coaching sessions, or 1 90-minute session each month for 3 months. They got to receive one or the other. And you have to pick. And you have them pay. How much money is this whole entire 3-month package going to be? Are they paying for it by month, by session? Are they paying for it all at once? Do they get a discount? What happens if they're late? Like, there's no language about this. They do have, this does say, you can pay by cash, check, or charge. I don't want you having any of your clients paying by cash. I don't know why someone would have that in there. So don't do that. You want a paper trail for all this stuff, okay? This isn't like a lemonade stand. The monthly agreement, in a way, you're agreeing to agree. But however, like what you're going to do after the first 3 months, but you could definitely put that in there. How it's going to work going forward, that there's going to be some kind of mutual agreement to have a monthly coaching program. Here are the 2 different options that you can choose from. But be aware that it is a agreement to agree, and that most likely what you're going to do is have a separate contract that they're going to sign when they do that. It's going to be short. It's going to be like an amendment to this contract. Fees are payable in advance on the first of the month. We don't even know what the fees are, so I don't even understand that. But the client agrees to pay the monthly fee. So this is very vague about what the terms are. And then that's it. Then they're like, here's your credit card. There's not even, was there even anywhere to sign it? There's nowhere to sign it. Okay, so you want people to sign it. You should be signing it. They should be signing it on behalf of your company, on behalf of them, because they're a human. If they're signing for coaching as a business, on behalf of their business, you're going to want other clauses in here. A whole bunch of stuff. You're going to want to know what's not included. What are their duties? You want to have a bunch of waivers and things, how you don't guarantee results, and how this is not therapy, and you can't, like, you're not responsible for damages to their business. You want to have stuff in there about kind of a bunch of lawyery things. So all those clauses, like I was talking about before, like the severability clause, and you're going to have no assignments, and this is the entire agreement, and all this stuff. So there's a whole bunch of clauses, that lawyery stuff. And there's also just this has gotten some inherent vagueness. And they're not signing it. Now, I'm not saying you have to sign something for it to be a contract. That's not true, actually. You have to assent that you agree. Like, that has to be evidence of agreement. But a signature is, one of the ways to do that, and everyone understands that they're signing a contract, and it's a great way to show intent. So I highly recommend people sign it. You do not have people have to sign it by a pen. You can actually, I put a clause in there in my contract saying people can sign electronically or by fax. I mean, we don't fax that much, but you can even use a website. I use like Right Signature, and there's a couple other sites where you can have people sign electronically online. In a lot of ways, it's even better than having them sign with a pen. All right, a business consulting agreement. This one I downloaded because this is from some entrepreneur.com forms thing. This one, a business consulting agreement, it's only a page and a half. And by the way, I'm going to have links to all these so you can actually look at them. Okay, business consulting agreement dated between so-and-so and so-and-so. Obviously, we want to know whether these are companies, consultant services. It has this incredibly vague statement. I'm assuming that this is an incredibly vague statement that you're supposed to replace when you actually use this template. So please do, because I don't even know. The consultant, the company employs a consultant to perform the following services. So I'm assuming that you're supposed to like insert the services there. The terms agreement, the agreement will begin and will end. Either party may cancel on 30 days notice. I really like the long notice period, because even though that can be very detrimental to people who want to cancel, right? You're stuck with this person and paying them for another 30 days. It actually is great evidence of showing that this person is an independent contractor and they're not an employee, because there's a risk that's very different than if you hire an employee that is at will and you can fire them and have them leave that same day. It's anticipated the consultant will spend a certain amount of time, but it will vary week to week. That's another thing that helps show that they're an independent contractor. The place is will perform more services at XYZ. In a perfect world, you would not tell them where they can do it, because they're an independent contractor. They can do whatever the heck they want. But of course, I know that sometimes a contractor needs to be on site. So I would put in language about contractor needs to be on site for these services XYZ, but they don't always need to be on site. You know, here's all, and otherwise they can do it wherever in the world they want. Payment, the consultant will be paid the rate of X dollars per X dollars of work. Okay, you really don't want to pay someone by the hour unless you really have to. It's much better to pay them by the month or pay them by the project. It's much greater. You're reducing your risk of them being categorized as an employee. And also, it makes it simpler in a lot of ways. You also probably want them to send an invoice, which they have, and you're paying them within 10 days. That's great. It'd be also good to say how you're going to pay them, but maybe, are you going to pay them by PayPal? Are you going to pay them by check? Are you going to be wire transferring? Sometimes that really matters, especially if someone is off-site and they're in another country. They may want a wire transfer, etc. Independent contractor. So some language here about being an independent contractor. It actually talks about the taxes, which is good. I may also put in there, actually I would, for sure. I put in a clause about how the fact this is not a partnership, this is not a joint venture, they're not agents for each other, all this kind of stuff. So more stuff about that. Confidential information. So, dude, there needs to be a lot more about this in here, okay? There needs to be an NDA. There needs to be a lot of stuff about the confidential information and the trade secrets and the copyrights and the trademarks and all the IP involved and who belongs to what. This is not adequate. Almost no matter, I would say no matter what consultant you have, there's going to be some trade secret, trademark, copyright stuff of some kind that will be created. They're going to write something. There's copyright law right there, okay? They're going to know about your internal company stuff. That's trade secret law. So there's got to be a lot more information about that. There needs to be an NDA, a non-disclosure agreement inherently in this contract. I like to have them in the contract. I think it's much, for a host of reasons. Part of which purely make it easier to understand. And you're going to want to know who owns everything. You also want them to have a duty they have to give it back to you at the end. Like if they have any information, if they have stuff in their computer, they have to give it back. Because you want that in the contract. So if they don't give it back, you can go make them, right? Otherwise, there's nothing in here saying they have to give us your stuff back. Employed by others. The company made from time to time requests the consultant arrange for the service of others. All costs paid by the company. Yeah, this makes me nervous. Because in no event shall the consultant employ others without prior authorization. Very dangerous. That's starting to look like an employee. Because if someone's really an independent contractor, they can subcontract with whomever they want. The only thing you can put in some great language about that they have to have their subcontractors sign an NDA. They're responsible for any damage that their subcontractors do. You can put in there stuff to protect you from a confidentiality perspective. But it needs to not, unless it truly needs to be a personal services contract because this consultant is going to sing at your event and they need to be a good singer. They can't have a different singer show up. There's certain kind of personal services that you actually want that person to be there for. But generally speaking, they can subcontract whoever they want. And so when you start limiting that, it looks like an employee. Signatures. You have the signatures there. I obviously talked about before how I want it to be the company signing it. So it's so-and-so on behalf of the company. The last thing I was going to look at was this joint venture that I found. First, I highly enjoyed this disclosure saying I'm not a lawyer, but here's a contract. This is a great lesson for all of us, is that if someone's not a lawyer, do you really want to use their contract? Maybe not. Well, that's the answer. It's not just because you want to know if it's valid under your state's law and all that kind of stuff, but also this person, we have no idea where they got this stuff from, and because it's definitely true that not all lawyers are good at drafting contracts. I'm sure that not all non-lawyers are going to be drafting a good contract. Okay, so let me change the region and make it a little bit bigger so we can actually see this. So we have this letter agreement. Okay. So this happens a lot with joint ventures. And what happens is, and this happened to me earlier this week, where business people who are not lawyers get together and they decide to like do some kind of joint venture of some kind. And so they exchange things that may be called letter agreements, they may be called term sheets, they may be called good faith agreements. And really, what these are is the kind of business person's terms of the agreement. And everybody does this. I mean, Fortune 50 companies create stuff like this. And the idea being is we need to start somewhere. We're doing the negotiations. We don't want lawyers involved yet. We don't want to draft, you know, all these crazy like warranty clauses and force majeures and stuff. We want to just know like what the terms we're agreeing to. So I get that. Okay. And this is what I do with my clients. I want to know the basic terms from them. And I want them to get that negotiated with the other side. This is not, though, the contract. Unless you don't have a contract, and then it ends up being the contract. And it's a very scary contract for me as a lawyer because it's missing tons of stuff, yet you're both signing it, so it's probably binding on you going forward. But it has inherent vagueness because it doesn't have everything in it. Like it has things like, you know, this letter agreement may be revised from time to time. Like, what? No, we're not just revising it randomly. Both parties may end this deal at any time. No, that's terrible. Because you say before, this venture will start at so-and-so and continue for 5 years. Unless it's terminated by the parties. And then later on you say both parties can end this deal at any time. Then how is it 5 years unless anybody can end it? That doesn't even make any sense. That's just a scary kind of contract. The client agrees to process the credit card hours and split the gross profits. That sounds like a partnership. That sounds, you don't even want to go there. You need a whole bunch of stuff in here saying how it's not a partnership and how it's not a joint venture and stuff. I'm ranting on this a little bit because it's an important example because this happens all the time. Is that two business people, two business companies, it could be even gigantic, large corporations, create one of these letter agreements, term sheets, good faith agreements, whatever they want to call it, and then they never actually do the real contract. They never get the lawyers involved, or a lawyer, or anything, or a template lawyer involved. And then this is it. And so if it doesn't go well, no one knows what's supposed to happen because it's inherently vague. This venture is supposed to last for 5 years, but it can end at any time. Well, I don't even know what that means. Okay, how is someone supposed to comply with this? You're going to be splitting the costs. Well, but who actually writes the check for that? Who pays for it? And who gets the money back? Client processes the credit card hours and splits the gross profits. How are you calculating the gross profits? Because gross profits is actually not it's gross revenue. Profit isn't gross. Profit's after. So like, I mean, I'm teasing a little bit because it's not really true, but like the idea being, I don't know what money comes in, what money goes to what. So actually from a business perspective, this isn't even a good contract. But from a lawyer perspective, this is inherently doomed because no one's going to know what anyone's supposed to do. This is a place to start and not to finish. So my warning to you is remember that when you do these kinds of things, it totally makes sense that you're doing it. I actually would say don't sign it because you don't want to fool each other that this is really a contract and you want it to be obvious that it's not a contract. I would not call it a letter agreement or a good faith agreement, especially if you call it good faith agreement, then you're under the duty of good faith. Unless you're in California, in places where you have statutory duties of good faith and stuff like that. You want to not be in good faith because good faith has duties. It makes things complicated. Call it a term sheet. Term sheet is inherently like vague in the sense, vague in a good way. Don't have anyone sign it, then it's not a contract. It still could be a contract, but it makes people intend that it's not a contract. You don't want to have it, you agree as follows. You just want to have just a term sheet, okay? And just stuff on it, right? And then you go have an attorney draft this thing up. If you're the kind of person who's doing a lot of joint ventures and they're all very similar, like, you do a lot of, you're doing a telesummit, and you have a whole bunch of people who are presenting your telesummit, it's that kind of joint venture, then you have an attorney draft one template for you to use with these 20 people who are going to be at your telesummit. You know what I mean? So this doesn't have to be inherently complicated and horribly expensive. This particular template has a non-disclosure agreement, so that's good. This is not a good non-disclosure agreement. It says, that these things are proprietary and confidential. It defines it in this very vague way, and that we're going to hold it for certain terms of years, but it doesn't say what happens. Because when I have a non-disclosure agreement, I put in there exactly what the proprietary and confidential stuff is. Not exactly in the sense of listing the titles of it, because some of it you don't know yet, but like the categories. And if somebody violates it, then you can go get an injunction. We want that expressly in there, because it's all nice and good to say that they have to do it, but if you're just going to sue them for damages, your private stuff is already out there in the world. Okay, you want to be able to get an injunction. You want to be able to have a court order that they can't talk about it anymore. In this case, they actually have a much longer contract that they say that you can use too, that goes into exceptional detail, is very, very lawyery, almost to the other extreme. And then he has all kinds of stuff he's selling at the end. The point is, I actually was using some bad examples, not bad in the sense of they're not helpful, but some examples of templates that are easily found within one of the first couple, if not the first, though, the couple first results on a Google search. But these are examples of contracts that aren't enough. You can get some half-decent contracts online. Typically, you have to pay for them. I'm not saying you have to pay a whole lot of money. You might be paying, one of these services. But generally speaking, you want a contract that actually had a lawyer involved, and you know that a lawyer was involved. Because then hopefully you actually know the lawyer in a perfect world. But even if you don't, and you're not going to pay an attorney to do it one-on-one, you want to make sure that wherever you're getting this contract from, there's lawyers that work there, right? Drafting these things. Makes it much more likely it's not going to miss stuff and have big holes, and makes it much more likely that it's not going to be unenforceable in your jurisdiction. Because that's one of the other big things. There's a lot of clauses like non-competes that are not enforceable in certain places. So it is possible to find good templates. These are not good templates, but they're a good place to start. So thank you for watching. This is just a quick little video that I shot here for you guys this afternoon. I hope this was helpful to give you some ideas about using templates and what's important to include, and give you some red flags for where the problems are. So thank you guys for watching. I'll talk to you next time. Bye-bye.